Everybody say, ah. Say, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyina. Uya matinyina. Uya matinyina. Oh, uya matinyina. Yeah, so uya matinyina. Uya matinyina. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will you make one cover? 1, 2, 3. I can breathe without you, say. I can breathe without you. I can move without you, Lord. I can move without you. Hey, who am I without you? Who am I without you? Say, I can live without you, yeah. I can live without you. I can breathe without you, Lord. I can breathe without you. I can move without you, yeah. I can move without you. Who am I? Who am I? Who am I? Who am I? Hey, who am I thinking now? Who am I thinking now? Who am I thinking now? So, who yeah? Who am I thinking now? Who yeah? Who am I thinking now? So, who yeah? Who am I thinking now?
Hello, viewers and listeners. Once again, we have met on this important platform, Community and the Law Show, brought to you by BWF TV. This is in collaboration with BWF Solicitors. This is your Community and the Law Show, your #1 community platform. We bring you all the wonderful things, the news, the updates, things to know, things to do, all about immigration, all about family, all about employment, civil litigation, dispute resolution matters, contractual breaches, and everything that you need to know about your legal position. This is the Community and the Law. Today we have some important things to discuss. We're going to home in on Section 3C, which is a very vital provision of the Immigration Act of 1971. We're also going to be looking at what you have to do when you have overstayed and what sort of amnesty or what sort of grace period you have under paragraph 39E of the immigration rules. We'll look at the implications of making a fee waiver application and waiting for a decision whilst your visa has already expired. And what if you are told that you have 10 days to apply and you have been rejected for the fee waiver, so you have to pay for it? What do you do if you do another or make another fee waiver application? What do you do if the employer is pursuing you because your visa has expired, the decision is not yet in, and the employer wants to protect themselves? What do you do? It's all about practicalities of Section 3C of the Immigration Act of 1971 and the paragraph 39E of the immigration rules. You are at the right place at the right time, Community and the Law program. We are going to be looking at updates. We are going to be looking at the NAP. We are also going to be looking at some reviews that have come through from viewers, from our clients, from the community, and we'll then look at the topic for today, and we'll take your calls, answer your questions, all for free, because this is free legal education. Stay there, don't go far. We are going to turn around with the commercial and we'll return to start the show. Community and the Law, brought to you by BWTV in conjunction with BWF Solicitors. Stay put.
Hello. There are several questions in the community when it comes to the law, especially with the immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, viewers and listeners. Once again, you are through. This is the Community and the Law platform. You are live on BWTV. Today's topic is Practicalities of Section 3C of the Immigration Act of 1971 and Paragraph 39E of the Immigration Rules. What do these provisions mean? How do they affect me in practice in terms of my status in the UK? What do I do once I go beyond these provisions? So this is what the conversation is going to be about. We'll bring you the nugget and we'll take the quiz at the end of it. We expect you to invite your friends and family and let's all learn together. So today we are going for that. So the first thing that we want to look at is a question that has just come through. And this is regards BWF Solicitors family. Please, I have a visa now. So basically, I arrive at Kotoka Airport, flying to UK in January. What do I have to provide at the desk now? Is it a code or what? Is it coming back flying to UK in January? Well, whatever you have, you should know that you should have done your e-visa. So please make sure that you've done the e-visa. Even if you are abroad, make sure you've done your e-visa. And if you are holding, of course, pre-settled status or settled status card, you know that you are not part of this e-visa conversation. But whatever it is, make sure you've done the e-visa. The next one.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, viewers. Hello, listeners. Once again, thank you for staying put. So, we are going to reviews that we have received from our client. This client says that look no further because BWF Solicitors is the best place for your immigration process. I started with nothing, but now God used BWF to help me get my stay. I'm not just holding leave to remain, but I am a British citizen. I highly recommend BWF Solicitors to you. Thank you for recommending us. Once again, another viewer, it says that my greatest appreciation goes to Mr. Bernard Owusu for his support towards my successful visa application. Thank you so much, and not forgetting my caseworker, Miss Abigail John. You have indeed put a big smile on my face. I strongly recommend BWF Solicitors to anyone out there looking for support, looking for solution, who is going through challenges regarding immigration and need a lawyer. Thank you. Next is saying that I contacted BWF Solicitors for support regarding my immigration work. And it goes on to say that lawyer Charles Asma gave legal advice and supported me meticulously through the application process. He helped me to understand the process and to ensure that my application goes through. Charles also advised us how to compile and ensure that the documents and everything are available and ready for use. Thank you, BWF Solicitors. I recommend them to you. So, viewers and listeners, the last one is that very dedicated and efficient service, far exceeding my expectation. I highly recommend BWF Solicitors. Thank you very much. This is a sample of range of positive feedback that our clients continue to give. And it tells you that your community lawyers are always available and ready to put smiles on your face. This is what we do best. Now, the update. We know that we have electronic travel authorizations for visitors that come to the UK. and making sure that, just like if you are going to America, you have to make sure that you do what we call ESTA. UK is introducing the same process. It's called electronic travel authorizations for visitors to the UK, and this has been extended to most non-EU countries. So what does it mean? The UK government has now extended the electronic travel visa to more non-European countries from 8th of January 2025. Excuse me. And electronic travel authorization gives permission to travel to the UK, but it's not the same as a UK visa. All applicants from from visa countries. Visa countries are countries that require visa to travel to the UK if you are a national of such countries. So all applicants from visa countries, including Ghana and most African countries, must continue to apply for their visas in the usual way until they are told otherwise. An electronic travel authorization lasts for 2 years. Visitors can travel to the UK as many times as they want during that time using the same electronic travel authorization. If you obtain a new passport, you will need to apply for a new authorization. Now, just to clarify, this is not a free visa, so please take note. So this is for people who do not need visa to enter the UK. So you pick your passport, you enter the UK. Most countries in Europe have bilateral agreement with Britain. US, Canada, and some other countries have the same agreement, and therefore the citizens do not need a visa to travel to the UK for a limited period. And so in the past, all you needed was your passport. But the new arrangement is that in addition to your passport that allows you to travel to the UK without a visa, this time you have to apply for permission. We call it authorization to enter the UK. And this will help the country to ensure that only people who are risk-free enter the UK. So the arrangement is to screen and ensure that people's background are checked for risks such as terrorist-related activities and so on and so forth that they are engaged in, so that only authorized persons can enter the UK. Even if your passport allows you to enter the UK without a visa, you need electronic travel authorization to be able to enter the UK. This is not for countries that already need a visa. If you need a visa to enter the UK, please, you still need a visa. This is not a replacement. The next thing is that publication of information relating to court proceedings. Of course, this is our nugget for the week. So the nugget is that publication of information relating to court proceedings held in private. So the court in England and Wales often sit in private, in that some decisions or proceedings cover individuals and therefore they have to be kept protected. And so once the court has sat in private, which does not allow journalists and the media to cover, that is private proceeding. In this case, any information relating to that hearing or proceedings can only be used if the person or the individual that requires the use of the information has sought permission from the court. If you do use the information without permission from the court, that is contempt of court. And so, in situations where the proceedings relate to exercise of the inherent jurisdiction of the High Court with respect to minors, minors are people under 18 years, so children, or the proceedings are brought under the Children Act 1989. And in this case, we are looking at things that relate to children, child arrangement orders, specific issue orders, special guardianship orders, and all those proceedings relating to children and the 1989 Act. You need permission from the court. Again, proceedings under Adoption and Children Act of 2002, you need permission from the court. Or matters that relate wholly or mainly to maintenance and upbringing of a child, you need permission from the court before you can use the information. What if you don't? If you don't, then I'm afraid the penalty is offense of contempt of court, and this shall be a fine of 2,500 or imprisonment of up to 2 years or both. This is under Section 12, subsection 1 of the Administration of Justice Act of 1960, and also Section 14 of the Contempt of Court Act 1981. So please take note. If you are giving your immigration work, to somebody to do it for you, and you give something to the person, for example, child arrangement order document to the person, and the person goes ahead without first seeking permission from the court, that will be a breach of the law. You'll be in trouble, and the person will be in trouble. So please take note and ensure that you adhere or follow the rules under this law. So now we move on to our topic for today. Today's topic is simple: practicalities of Section 3C of the Immigration Act of 1971 and paragraph 39E of the Immigration Rules. What do they say? What are the implications and what are the practicalities of these provisions? So we're going to take them one after the other, and we'll look at case law position, and we'll look at what actually happens in practice. And with that, we'll be armed with plethora of information to be able to know what is best for us, especially dealing with employers and ourselves when our visa is about to expire or has already expired. Section 3C. We're going to ask producer, if you are there, please take us to the 1971 law and take us to Section 3C. We will read the law and look at practicalities of this law. So Section 3C, if you scroll down, 3C. Right, so Section 3C is what is on the screen. You go through and it tells you things that you don't have to worry. When do you not have to worry, and why should you not? So in a nutshell, Section 3C is a protection. It's a protection. We call it a sword, and it's also a shield for you. So it's a foolproof protection. What does it mean? It means that if you have visa and you renew it, and the time of renewal, or at the date of renewal, your visa has not expired, you have made an in-time application. In-time application means your visa did not expire before you renewed or applied for a new one. As a result of that, whatever protection you had on the basis of the visa you had up to this point of renewal, the protection will follow you. So that is the shield. It's also a sword. Why is it a sword? It is a sword because you can rely on the same right to fight your case further. You can rely on the same right to work. You can rely on the same right to live your life up to the point where the decision is made on the new application. So Section 3C is simply that if you apply before your visa expires, you are protected until the decision is made on the new application. Now we go to paragraph 39E of the immigration rules. You can see that paragraph 39E is a rule covering immigration casework, but Section 3C is a statute provision, Act of Parliament. They are both useful and they both carry weight. Under paragraph 39E, the law says that the rule, should I say, says that if your visa expires, this time you are late for whatever reason, your visa has expired, but things happen. It might not be your fault. It could be due to sickness, due to whatever. And so the law or the rule says that you have 14 days from the date the visa expired to apply for a renewal. So in this case, even though you had your right, it's not as great as your Section 3C protection. So here it's a grace period. So the grace period is that your visa has expired today, you've discovered it tomorrow, and from that date of discovery, let's say it's expired yesterday, you've discovered it today, you have 14 days from today to put in an application. And the rule is that the grace period allows you to apply without the immigration or the caseworker saying that you didn't have visa and therefore you were illegal. So technically you were without, but for the grace period, you were able to apply. So these are the differences between Section 3C and paragraph 39E. What are the practicalities? So we take a case of John, who is applying to switch from current leave to another leave or to renew the current visa because the visa has expired, is expiring. John made the application today and the visa expires today. Has John made an in-time application? John applied before the visa expired, and so the visa is in time. Under the rules, we call it exempt leave. Exempt leave in that the leave is still valid. And so once you apply before it expires, you are within. Section 3C will give you the protection you need, which is a foolproof protection. Because you applied before your visa expired, you are able to live your life in terms of job. The employer cannot say that you have to go and bring or wait for the new visa to be issued before you continue your work. No. The employer has a duty to ensure that you continue to work because you are protected under Section 3C. You switched from a visa to another visa category. At the time you were switching, did you have a valid visa under the existing one? If the answer is yes, you are protected under Section 3C of the law. What can the employer do? As long as you are protected under Section 3C, the employer can only go to the Secretary of State or the Home Office to ask them, does this person have right to work, to continue to work for me? It is then the Secretary of State or the Home Office to say that yes. The employer cannot say stop until your visa is renewed or the decision comes. You can continue to work. The employer is supposed to go online and make an application for what we call employer check-in service to confirm or to check that the person had a visa or leave before they applied to renew. And so they are protected under Section 3C. Once the employer applies, the employer will receive a confirmation, a verification from the immigration officers or the Secretary of State or the Home Office. And there are two outcomes. Either they will say yes, positive verification, ticked, or no, negative verification. Sometimes they will say, we can't see anything to say, but it's mostly yes or no. Yes, the employer is protected and they can continue to keep you. No, the employer has a duty to ensure that they don't risk taking you or continuing to work with you. And there are instances where you are protected under Section 3C, but the verification will come out negative. That will be an error or a mistake. You can challenge that for them to correct it. Whose responsibility it is to check whether you are protected under Section 3C? It is the employer's responsibility. However, you also have a duty to ensure that you support the employer. So you can also check. Again, if you did a share code, it will show that on the profile for your leave, the date it expired or is there, and you can confirm as to when you renewed it. So what you need is evidence that you applied before the visa expired. How do you prove it? The visa application copy, which has date of application and the time of application. This can be compared with the date of the visa expiration. Once we see that this one was there before you applied, you are okay. If it is the other way around, then of course the employer will conclude that you didn't have leave before you applied. Then we'll go into paragraph 39E to see whether you are still protected as far as the employer's duty is concerned, to ensure that the employer does not hire an immigrant or an illegal immigrant. So that is how Section 3C works. What if you applied for a fee waiver today because your visa is expiring today, and tomorrow your fee waiver has not come, and so your application is not yet gone? Are you still protected? The rules and the laws say that yes, you are still protected, because at the time of the fee waiver application is the starting point of the substantive application that you are to make to renew or to switch your leave. And so you are still protected. Where do we break? Or where does the chain break? The chain will break once the fee waiver decision has come through and the fee waiver request is rejected. Once it is rejected, you will be given two options. Option one, to pay and submit within 10 days, or to, if you choose not to progress, you become, or you are out of leave, or you are without leave. So if, for example, fee waiver comes and you apply again because you think that you want to apply again, the moment you put in another fee waiver, there is a break, because once it goes past the 10 days before the new fee waiver decision comes, you were without leave at the time that the decision came. Somebody will say, hang on, I had 10 days to put in an application, but I didn't wait for the 10 days to be up, so I applied for another fee waiver. Why should there be a break? There is a break because you can only attempt one fee waiver application for that renewal. What if you don't have leave at all? If you don't have leave at all, you are not protected under Section 3C. So that is not for you at all, and you don't have to worry because you have nothing anyway, and therefore you just wait till the application you have made comes. In this case, you can even make another fee waiver application, but you cannot make another fee waiver application if you are under Section 3C protection. Let's also look at Section 3C, paragraph 39E, and how this will affect finally going for indefinite leave to remain. And we are looking at the case of Afzal, which has come through recently from the court. The court position is that if you are under Section 3C, you are fully covered, no excuse. If you are under paragraph 39E, you are half covered, because that is just grace period to allow you to make an application, not to benefit from the delays at the Home Office. And so, if you apply under Section 3C to renew or to switch your application or your visa, you are protected, and your continuous residence will continue and will be the same as from the time you applied, where 3C covers. But if you applied under 39E, paragraph 39E, because your visa expired yesterday and you applied today within the 14 days grace period, remember, at this point, you are without leave, And so there is no exant leave. And because you didn't have exant leave, the application will be considered under grace period provisions. And so, as long as the application stays with the Home Office for whatever number of period and it comes, the counting period will be the date you made the application up to the date the decision came. And this will be subtracted from how long you have lived in the UK for legally. You have to make up for this time or gap before you qualify for indefinite leave to remain, the 10-year continuous residence under Section 117B. So these are the practicalities. These are the nitty-gritties. We are going to pause here and take a commercial break. Once we return, we will share the studio number with you so that you can dial in and ask your question for free legal advice. In the meantime, please feel free to send your questions through the portal or the chat so that this will be read and answered for you while the show continues. Don't change the dial. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to the show. You are live on BWTV. Just so you know, this is where you get to ask questions for free advice, no consultation fee. And so, if you care to save on consultation, this is where to ask your question. Where do you, or what number do you dial? The number to dial is what I have for you here, and it is 0208 493 7345. 0208 493 7345. That is the number to dial live into the show, and we will be glad to answer your question and give you free legal advice. The show continues. Practicalities of Section 3C of the Immigration Act of 1971 and paragraph 39E of the immigration rules. Which one is a sword? Which one is a shield? Where do you make gains? And where do you lose out? What do you do if the employer is chasing you because your decision has not been made? Are you under 3C, 39E? Does the employer have the right not to keep you until the visa comes? These are the things we are covering on this show. Now, the employer. We know that employers are also under the law to ensure that they hire people with leave to remain in the UK. Employers' duty extends to the point where they have not done due diligence before hiring the person. Once they are caught, they will be asked to pay a fine as much as 40,000. So the employers are very careful. However, the employers must also know that individuals have their rights and protection under Section 3C. So the question to ask is, when did you renew your visa? The employer's question is to you, and your answer is to tell the employer when you renewed your visa. So your visa expired yesterday. You renewed it yesterday. What time yesterday? The time is up to 11:59 p.m. So as long as you apply before the end of that day or date, you were within. And so at the time of your application, you had exempt leave. Can the employer say, wait till the visa comes? No. What would the employer do to protect themselves? One, the employer will take a copy of the application you have submitted. There is a UAN number, unique application number, which tells the application you have made, the time and the date. The employer will then rely on that to protect him or herself in case they are questioned. Furthermore, the employer also is required, if they choose to, protect themselves further, to apply for employer check-in service. They make a call to the Home Office to find out whether the person had leave before they renewed, or they go online to complete their ECS form, ECS, Employer Check-in Service form. Once they've completed the form and submitted, a decision will come through a few weeks later or days later. And the decision will be the person can work or they are covered under Section 3C. So there will be positive verification. If it is positive, the employer will place this on file. If it is negative, then the employer has right to ask you to stay home. If there are issues, your lawyer can then speak to the Secretary of State, challenge them by way of pre-action protocol to say that because of your mistake, I'm losing my job, and the Secretary of State or the Home Office will fix it. This applies also to applications made under paragraph 39E, where you applied at the time your visa has expired, but within 14 days. The difference is that 3C is a shield and a sword, so foolproof protection. 39E is a shield. It's a protection, but not fully. And so, in terms of continuous leave for indefinite leave to remain, it is not a sword to cut through that 10-year continuity rule. And so, if you came late to renew your visa, which is paragraph 39E, you have to pay the penalty of lateness. The penalty of lateness is that because you came late, whether 14 days, 1 day, or whatever number of days, that will be there. The application will be decided after some time because you have to go for your biometric, you have to wait for the decision. If it takes 1 year for a decision to come through, plus the days lateness that you put in the application for, put all together to get the number of days. And that will be the penalty point to pay. How do you pay? You pay by making that extra time before you can qualify for indefinite leave to remain. For example, your visa expired yesterday. You applied for renewal today, 30th of November 2024. Are you covered under 3C or 39E? You are covered under 39E because you are late. And because you are late, you have to wait for how long it will take for the decision to be made on your visa. Let's even assume that you apply for a fee waiver before you made the main application. That will even be longer. So for you, it's taking you 1 year for you to get a decision back. It was late for 1 day and it stayed with them for 1 year, 365 days. So plus your 1 day, that is 366 days. What do? My visa ideally will allow me to apply for my indefinite after 10 years. And my argument under 3C will be that 10 years is up because whilst I was waiting for my decision to come through, I was still legal. So even though my visa is expiring next year, I've done my 10 years already because of the delay for which the decision took or the hard for it to be made. And for that reason, you can apply without waiting for the 10 years to be, for your leave to be up in the next year or in the next year and a half. That is 3C. But 39E, because you were late already, you cannot say that there was a delay from the Home Office. The delay started with you. And Home Office added to it, but you still have to pay for the entire delay. In this case, you have to wait for the 10 years to be up fully based on the gap or the delay, because you have to make it up. What if during the gap period that you are waiting for, the visa expires? If the visa expires, you have to renew again. Because you are not 10 years fully yet because of the gap, you have to go for another 2.5 to make up for the shortfall. That is harsh, but that is the case law, the case of Afzal. So at this point, we are ready to take your course. At this point, we are ready to take your questions. At this point, we are ready for you to participate. Remember, the number to dial is 0208 493 7345. 0208 493 7345. That is the studio number to dial. Please dial and ask your question. So the first question that has come through to us is from Victoria. Victoria is asking a simple question. Please, is the EU family members part of the EU visa? Victoria, the answer is no. Because EU family members hold pre-settled status or settled status, and they were given residence card, not residence permit. Their visa is already electronic and is available online, and so they do not have to go for e-visa. Prince is asking a simple question. Prince is saying, please, I want to know how to check if you were banned for 10 years and if your status still stands or if it has been revoked, please. Right. I mean, 10 years ban, depending on the circumstance. If you are deported, that's a different ball game. But if it's just a ban, it expires after 10 years because at the time you were banned, you were told that you are banned for 10 years. And once the 10 years has expired, technically you are covered. And so nobody's going to write to you to say that the ban is now lifted. It's there, but you have to count when it happened and whether you've done 10 years already. If you want to know whether you had a ban, you can apply for subject access request so that you get your details and know whether that visa for which you were refused, you were banned, and when it actually started. You can also refer to that refusal decision to see when it started. These are all options. There are instances where you have to apply for the ban to be revoked, and that is actually when you've been deported from the UK. So that's a revocation order for that deportation order. So if you've been deported, the order will be placed on you. And even though it's for 10 years, you have to apply for the order to be lifted or revoked. That is the difference between somebody who has been deported from the UK and banned for 10 years and somebody who applied and was refused and banned because the refusal was made under paragraph 9.7.2 of the immigration rules. We'll come back to take your questions. Dial the number, ask your live questions, and we'll be happy to respond to them for you. Community and the Law Show. We'll be right back. Commercial break.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, caller. You are through to BWF TV. Please ask your question. Hello. Pacho betumi akasa.
Okay. Good evening, lawyer.
Good evening. How are you?
Pacho, me bisa yama then the mechanism here.
Pacho,
then the usually now when you are indefinite, we by 2 years in it to watch on a life on the UK test, what pass away. Now, over to my naturalization straight and other to the or start draw another exam CBD come on other laughing you can now where you watch your passing nana. But your question, Annie.
Yo, yeah, that's the baby. Or not throw English in so come I.
Oh, okay.
Or not throw English into a friend Trinity College. Trinity College. Or from one no I catch on or naturalization exams. Or English exams at raw. Oberman test no or no I prepare on your aye.
Okay, Madasi.
That's bye. Hello, you are next to call for free legal advice. This is the only time you get to pay no consultation fee for personalized and on-point advice to your issue. Practicalities of Section 3C of Immigration Act of 1971 and paragraph 39E of the Immigration Rules. We have a question from Theophilus. Theo is asking, good morning, good afternoon, good evening. Please, I am EU family member through my uncle. Does my wife need English test before coming to UK? Right. Well, I want to believe that you family member through your uncle, you have indefinite leave to remain or settled status. If you have settled status, then of course you can apply for your wife to join you from abroad. Your wife is not applying under EU, and therefore full immigration rules apply. Your wife need English language at the right level, usually A1. If your wife has overseas degree, then they can apply for conversion through ECTIS so that they don't have to write the exams. They get conversion letter to support that. So you are free to call the studio line, and the number to that is 020 84937345. 02084937345. Dial the number and ask a question. Yes, this is coming from Grace, and Grace Press says, hello, lawyer. I'm in a temporary accommodation under the council. Is it possible to issue an invitation for someone in Ghana using the temporary accommodation? So our friend is asking, I want to invite somebody to visit me in the UK. Can I do that even if I'm in a council accommodation? I don't know how long this will be for the temporary accommodation. However, the matter is not the fact that the person will have a place. If somebody is coming to visit you and you have 2 rooms or 1 room and a living room, depending on your family size, and you meet the Housing Act of 1985 Part X, then you are able to invite them. However, the decision to give them the visa to come to the UK to visit you is not based on accommodation, but based on the person's own circumstance in Ghana. So it's all about them and not you per se. So yes, you have accommodation, and depending on the accommodation situation, you will be able to invite somebody, provided there's space for them to stay. Veronica is asking, please, I did English test, which is 2 years. When I was having the renewal, I did use it. Now I'm going for my leave to remain. Please, can I use the same English test? Usually when you are applying, they will ask you, have you made a previous application and met the English language test? You say yes or no. If you say yes, they will ask you for the details. If you say no, then you have to show the new English test that you have done. And on that basis, anytime you are renewing and you've done the English in the past and met the English threshold, more often you can say yes and go through it. Again, if you want to do it again, because the English test has been 2 years now, of course, not hard, as you know, so you can always refresh your memory, go for some practical aspect of the new versions of English by doing the test for yourself, for your confidence, and for your immigration application. 3 in 1. And for the 3 in 1, I can say you can go for another test. However, if you've done it before and met the English language, then you can renew without another. This is coming from Naomi. Naomi is saying, I'm an EU national. I want to bring my wife. Does she need to... Naomi. Okay, I'm sure Naomi is asking the question for somebody. But even if it's for Naomi, we are in the UK, a liberal state, and therefore you are free to bring your wife. So Naomi, does she need to write an English test? The answer is yes. Do I have to go home to marry her, or can she go through customary marriage in my absence, please? So the first one, the answer is yes. She has to do English and pass up to at least level A1. The next one is that marriage is important. Under the rules, you should have met your partner in person. So if you haven't met your partner and you only met on Facebook, Instagram, or somebody introduced you to each other, you've only been having a conversation on the phone or through video, you have to meet the person face to face. And so, depending on whether you've met already, customary marriage from Ghana under the Ghanaian marriage rules will be okay for proving that you are married and therefore the person is your partner. If you haven't met the person in person, then you have to meet in person. Either the person met you here or you met in the person's country. You should have met first physically. I don't know the specifics of your matter. If you need further support, please call us and we'll be able to assist you further. This coming from Charles. Charles is saying, please can the dependent make an application for the child by supporting it with DNA? Right. What we know is that DNA is not compulsory. However, it's helpful depending on the circumstance. What you need is evidence that you have a child that is your child, either as a father or as a mother. And the first reference point is the child's birth certificate showing you as father or mother. So can a dependent make an application for the child, but is it make an application for the child? So that this application, if this application is for the child, the same principle, but in this case, remember the child is a stepchild. And for the fact that this is a stepchild or stepfather or mother to this child, the application can be made. Remember, the DNA for the stepchild cannot work because this is not your biological child. But you need relationship with the child's parent to prove that because you have been in a relationship with a child's parent, biological parent, for 2 years, or you are married to the child parent, the child has become your stepchild. And so you can apply for this child, or you can apply for yourself, depending or relying on the status of the child. Because the question is not clear, that's why I'm covering all the angles. When both parties are making application for their child, and they want to support it with DNA, which of them will have to do it? I think is the point that is made that if both are applying for this child, the biological parent will have to go through the DNA process because that is the only common sense thing. Because the other parent cannot have DNA confirming them as biological parents. And so they will need something to show that they have a relationship with a child's biological parent. And that will be marriage certificate or evidence of durable partnership, living together for 2 years or being in a relationship for 2 years. Because we are talking about living with a child and a child mother, will be living together for 2 years or being in the life of this child's mother or father for 2 years. And you have to prove that. We have Kojo. Kojo's question is, my sister got married to an EU national. They married under UK law. Now, she has got settled status. The marriage has broken. Can she divorce in Ghana? Right. Now, so I will tell you the reverse order. A marriage contracted in Ghana, UK court, family court, has a jurisdiction if it is proven that the party making the application or both parties involved in this application have lived in the UK for 2 years, for 1 year, one of them or both of them, or they are habitually resident or they are domiciled. In this case, they have become a British citizen. Once the test is met, UK court have powers to preside over this marriage application and to declare it dissolved and to issue a divorce certificate, what we call final order after the conditional order. Now we go to Ghana or other countries. Because we are not discussing Ghanaian law or any other country's law for that matter in terms of family dispute and marriage separations and so on and so forth, we have to cross-check the law in Ghana, whether marriage contracted in the UK, Ghanaian family court has jurisdiction to cause the marriage to be divorced. If it is not, then you cannot. If it is, then you can. But if the marriage was contracted in the UK and you are living in the UK, why don't you go through the divorce proceedings in the UK for simplicity? However, you have a good reason for asking this question. And so my advice to you is speak to a Ghanaian lawyer. If I say Ghanaian lawyer, somebody in Ghana practicing in Ghana, and ask them to confirm. Or you can do the research whether it's possible for your marriage from the UK to be dissolved or had it separated in Ghana within the court process. Right, so the next question. If one applies for fee waiver in first-time visa application because of destitution, but while waiting for decision, someone volunteers to pay for the full application, are they required to withdraw the fee waiver application or notify Home Office? Do they have to include in their visa application source of income for the visa fee? Okay, so in terms of visa fee, you do not have to tell anybody where you got your money from. You are paying for it and they want the fee. So all they want is the money for you to submit. However, because you put in the fee waiver, you have two options. Wait for decision to come so that you know whether you've been given or not. So even if you have the money or somebody is ready to help with the fee payment, put the money aside and wait for the fee waiver that is already pending to be decided. Once it comes through and it is positive, you save the money. If it is negative, you'll be given 10 days to pay and submit the main application. So I would say you can wait. If you think that the person cannot wait because they have the money ready to help you, then you can go ahead and submit the application. And the fee waiver decision comes, all you do is ignore it because you have already applied.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back. So we are going to go through the nugget. We'll then look at the quiz and give you space to ponder and to respond and to share a thought. In the meantime, if you want to call to ask a question, you have the studio line 0208 493 7345. Now the nugget. So, producer, if you can zoom it for me. Thank you. So, we are told that this is about contempt of court proceedings. And the nugget reads, it is a contempt of court to use or publish information from court proceedings in England and Wales without permission from the court where such proceedings relate to 1. Exercise of the inherent jurisdiction of the High Court with respect to children, or the proceedings are brought under the Children Act 1989 or the Adoption and Children Act 2002. Otherwise, relate wholly or mainly to the maintenance or upbringing of a child. The penalty for the offence of contempt of court shall be a fine of up to £2,500 or imprisonment of up to 2 years or both. This is taken from Section 12.1 of Administration of Justice Act 1960 and Section 14 of Contempt of Court Act 1981. This is the nugget. Remember, you are told that these are the criteria for contempt. Children Act, matters relating to adoption of children, matters relating to maintenance of children and upbringing of children, and matters relating to children in general. These are all matters that cannot be disclosed or cannot be used without permission from the court. And so the quiz is a reflective of this nugget. And so your response should be taken in that context. Now the quiz. So Kwame Terrier lives in the UK. He has a 4-year-old child, Bejna, and this child is with Ama Atta. Due to disagreements, they live apart, and Ama initially refused Kwame contact with Bejna. Because of this, a family court in Watford granted Kwame a child arrangement order under the Children Act 1989, allowing him to see Bejna twice a week and to spend time with him from Friday 3 p.m. to Saturday 3 p.m. Kwame is renewing his leave to remain in the UK as the parent of a British child. His current leave expires tomorrow, and his solicitor has the child arrangement order as evidence of access to Bejna. Question: what should the solicitor do to ensure that Kwame submits an application in time so that he can be protected under Section 3C while complying with the law regarding the child arrangement order so that he will not be in contempt of court or the solicitor in contempt of court. 1. Kwame's solicitor should submit the application with the documents, including the court order, simply because Kwame's visa will expire tomorrow and Kwame is at risk of becoming illegal. 2. Kwame's solicitor should apply to Watford Family Court for permission to use the child arrangement order to support Kwame's application before submitting the application, even if the visa will expire tomorrow. 3. Kwame's solicitor should submit the application now. Apply to the court for permission to use the child arrangement order the same day that the application is made and provide the supporting evidence to the Home Office later. Which of the 3 options applies? Now we take your responses. 1, 2, 3. Which one do you think? Just while we are waiting for your response or responses, a question comes through from Gerald. Gerald is asking, an adult who had settled status a year ago is preparing for naturalization. Is the person supposed to do A1 or B1? Will be glad if you could explain. All right. So the person will need B1 because they are applying for naturalization. Usually B2, but B1 also suffices. The reason is A1 is for those entering the UK. Once you're already in going for indefinite or naturalization, you have to apply to show that you have to demonstrate that you have English language proficiency at B1, B2 level. The reason is that whilst settled status does not require you to provide any of those things, naturalization is not under EU law, and so you have to follow UK immigration rules, especially the Nationality Act of 1981, Section 6, Schedule 1. So we wait for your responses to the question. Again, Joe asks this question. If you have pre-settled and you do settlement scheme application, how long? All right. If you are switching from pre-settled to settled, how long? Well, the standard now is 9 months, 1 year, but it can be earlier than that. That's the standard. So viewers and listeners, we are waiting for your responses to the question. What should Kwame's solicitor do? Apply? Okay, Nana. Nana says, number 1, the solicitor should know that Kwame will be out of visa if the application doesn't go. So they should do it now. Damn the contempt of court. Kwame also says, I agree with Nana. Akosia says, I agree with my colleagues that came before me. Kofi says, 3. I disagree with the 3 and I go for 3 because the solicitor can go ahead and submit the application and at the same time apply for permission to use the order because the court says the permission will be required to use the order. Ifia says, 1. I disagree with Kofi, and I agree with the 3 that came before me. Yao says, I don't agree with any of all those who have come before. I want to be independent and stay at 2. Essie says, oh, I want to go with Yao because Yao is right. Kwabena says, I will go with the one who said 3 because 3 is the last option. Abina says, I want to go with the 3 because 3 is majority. Ni says, I want to play it safe. I'll stay neutral, number 2. Ahmed says, I will go with all the many people who said 1. The more, the better. I will join the crowd, 1. Right. What about you? Do you agree with Amma, Yao, Kofi, Essie, Ni? Which one? Your last chance to respond. We have a minute to end this part of the show. Option 1, option 2, option 3. We are going for a commercial break. Once we return, we'll bring you the answer and say well done to those who scored 100%. Commercial break. Don't change the dial.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back. You are through. You are the right place. BWF TV, bringing you good things and everything. So with the question, this is based on the nugget, and the nugget was about contempt of court. The summary of the nugget. All right, we have Mami. Mami says 3 is better, and I'll stay with those who said 3. Thank you, Mami. So the nugget says that under Section 12, subsection 1 of the Administration of Justice Act of 1960, England and Wales, and Section 14 of the Contempt of Court Act 1981, anybody who uses court information, court recordings, court orders, court directions need permission. So you need permission from the court, and so such person needs that permission. If the court doesn't grant permission and you use it, you are in contempt. That means you have disrespected the court. If you do that, you are in breach, and so there's penalty for you. £2,500 penalty, that is the minimum, or imprisonment for 2 years, or both. You pay money and you go in for it. So we have Kwame, who wants to apply for visa. He's actually renewing.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and sorry for that break in transmission. Technology is good. Technology sometimes gives us surprises. Yes, you are back on the show. So we got to the point where we were looking at the fact that if you use court information and you don't take or seek permission from the court, you are in breach of the law. And so there is consequence for it. And the information relates to things about children. And the question here is Kwame going to need anything about a child? The answer is yes, because we are told that Bejina is a child, 4 years old. Is Kwame going to need anything relating to child arrangement? The answer is yes, because we are told that there's child arrangement order. Is Kwame going to need anything under the Children Act? The answer is yes, because child arrangement order is a Section 8 order of the 1989 Children Act. And so it appears that if Kwame's solicitor does not do what is right, Kwame will be happy, but he will be in trouble. So whatever he's going to do must be one that will make Kwame happy and also not be in breach. So the best will be to submit the application before so that Kwame is protected under Section 3C. The same day, makes an application to the family court for permission to use the document, which is a child arrangement order. And then wait, because Kwame will have about 35 days, which is about 5 weeks, for him to go for biometric. Within that time, the court permission would have come through. Kwame books appointment for biometric enrollment. Then at that point, before the date of the appointment, all the documents will be ready, including a court permission to use the child arrangement order. Then we submit everything to the Home Office. This is how to avoid being in breach of the law. Answer is 3. So thank you very much once again to all those who said free. Your certificates are ready. You have passed Law 101, specifically the provisions under contempt of court. So later on you'll be contacted so that we issue the certificate to you. Proficiency of legal knowledge. Well done. And the rest who were nearly there, that is to show that you have to do a bit of it and you will be receiving your certificate the next time we meet on this platform. So, to the summary of today's conversation, we're looking at practicalities of Section 3C of the Immigration Act of 1971 and also paragraph 39E of the immigration rules. 3C says that if you apply in time, you are covered by the law. And so, until decision is made, you are fully protected. 39E says that if you are late and your visa has expired, you have 14 days to still apply. However, if you come late and it takes longer also for the decision to come through, the protection under 3C, even though you have it, you will not have it when you are due for your indefinite leave to remain application. And so that is the difference between 3C. So 3C is for life and 39E is temporary. And so you may be asked to do extra time to be able to qualify for indefinite or be ready for indefinite leave to remain. The law is clear, and so let's ensure that we stick within the confines of it and apply. However, no employer should undermine the provisions of 3C and demand that you go home until your visa is issued. That employer will be in breach of the very law. And so, if the employer is in doubt, they can go for the employer checking service to confirm that the employee has the right to work at the time they are waiting for the visa decision. This has been Community and the Law Program, your authoritative show on legal matters, brought to you by BWF Solicitors and transmitted on BWTV. Thank you for your time, thank you for your audience, and thank you for the patience. We will meet again on Thursday next week, Friday next week, and Saturday next week with another sections of what BWF offers. In the meantime, please do not forget that we are located at Anna House, 4th floor, 7 Sisters Station, North London, Tottenham. You find us at the very high road, So once you get to Tottenham, you get to 7 Sisters Station, you exit from the underground, and you call us. We'll come and usher you to our office. We open Monday to Friday, 9:30 to 6 p.m. Saturdays are for appointment only. And so if your need is for a Saturday, you can call to book appointment and the particular solicitor will be available to meet or discuss. We are also reachable remotely, and so you can reach us anytime that you need support. Our office lines are available 9:30 to 6 p.m. And so you can call us 0208 493 7340. 0208 493 7340. Or in an emergency, you can call us on 07712761884. 07712761884. All our workers are available and standing by to pick your call and to support you. Today, you heard the many people who are testifying to the work we do and how satisfied they've been. You are the next, and therefore we are ready to ensure that we take your case, work with you, and walk you through it to the end and give you a testimony so that you will share a message with the rest. Thank you Enjoy the rest of the weekend. Be good, be kind, stay put.